Bienvenidos todos. Como saben, tenemos invitados de lujo y vamos a hacer este panel en inglés en beneficio de nuestros invitados. So, welcome everyone. Thanks for being here. This fireside chat. We don't have a fire, which is good, I think, but we'll have a candid discussion among friends as it is intended. Maybe we'll talk a lot about football, if you don't mind. We'll have a good discussion with our friends from North America, and thanks for them to agreeing on being here and having this discussion. So first, let me introduce our panelists. As you know, we have as the host of this event, Alejandra Palacios. She's the chairwoman of COFECE. Thank you, Alejandra. Everybody knows who you are here. We also have Joe Simons. He's the chairman from the Federal Trade Commission. And before that, he was practicing law, so he knows the three jurisdictions very well from his practice before in a very important law firm. We also have Mekan Delrain. He's the Assistant Attorney General for the Antitrust Division of the US DOJ. He handles all things antitrust within the DOJ, so thank you, Mika, for being here. And we also have Matthew Boswell. Matthew is Canada's Interim Commissioner of Competition. He's the head of the Canadian Competition Bureau. And he's a good friend of COFECE. He's been helping COFECE for a long time in cartel investigation directly, so thanks for being here, Matt. It's an honor to have you here as well. So let me start with an easy question. An easy question is, how do you see the new USMCA? In Mexico, we call it TMEC. We, of course, have heard a lot of discussion around many issues, but specifically, of course, given the topic of this discussion, I would like to hear your views regarding the competition chapter. How is that changing from what we have in force right now? What do you see coming in terms of cooperation? So maybe, Joe, if we can start with you.
Sure. So one of the things I'm most interested in about the new agreement is the provision that deals with privilege and attorney-client privilege in particular. So we've had attorney-client privilege in the U.S. for a very long time, and based on my work in private practice, it became very apparent to me that that is really a critical aspect of antitrust enforcement in our country. And what it does is it creates a dynamic between the lawyer and the client, where the lawyer is, or the client is, feels much freer to talk to the lawyer and to do it ahead of time before activities or actions are contemplated, and to get advice about whether to do the activity, the conduct at all, or maybe to change it in a way that will be more compliant with the antitrust laws. And so what it turns out to be is a situation where you encourage self-compliance through privilege, or you certainly increase the ability of the private bar to engage in self-enforcement with a strong privilege. So I'm very, very excited about that. And hopefully, Mexico will and I know they're working at this very diligently, because we brought some people to Mexico to help work through that.
That's good. Yes, Mekan, you've also been very involved with this, helping the COFECE with the attorney-client privilege. So, how do you see this specific point? And in general, maybe you can give a view on the USMCA.
Sure. First of all, I think it's a great advancement in the continued cooperation that we have in North America between Canada and Mexico and the U.S., two of the three largest trading partners for the United States. So the continued convergence of what we do is really important. I think the agreement will lead to that. One of the important parts that adds on, which the attorney-client privilege is a part of, is just the broader procedural convergence towards procedural fairness, which I think is a real model in this agreement. And I'm proud to say that the competition chapter was the one where it was closed first. It was done before my arrival or Joe's arrival, so we don't take credit other than pride in the fact that that chapter was done. But I think a lot of the provisions dealing with transparency, a lot of the issues which are frankly the model of, hopefully a broader multilateral provisions is in that chapter and something that we can continue to build on. We've had the attorney-client privilege is a very important part of the U.S. legal system. As Joe mentioned, it's an important part of competition enforcement. And to the extent our experiences could help animate, as you guys have been implementing that in your laws, we'd be happy to provide all of our resources to assist in that.
Thank you very much. Matt, what do you think about USMCA?
Thank you, Carlos. Thank you as well to Alejandra and Professor for inviting Canada to join the discussion today. So obviously, we're very happy that our countries have reached a deal, and as Megan says, continue to have our collaborative relationship in trade and, more importantly, in competition, having created the chapter, I guess, April 2017, the first chapter, a big win, one that I think we can build on for other FTAs going forward, with emphasis on procedural fairness, as well adding in some consumer protection language in there, which from the Bureau's perspective is important because we have that mandate. I think if I could just add on to the solicitor-client privilege issue, of course, is a cornerstone of the Canadian legal system, the notion of solicitor-client privilege. But I should say that in terms of enforcement, it does sometimes present us with some issues when there are overly expansive claims of solicitor-client privilege, particularly in the cartel context, where we've conducted search warrants and parties claim solicitor-client privilege on all the electronic records. As out of an abundance of caution, I'm not impugning the motives, but it then drags out for an extended period of time when we work our way through those claims. So it's a fundamental concept, but it's something that can get in the way of efficiently advancing investigations if you're not careful about it and careful on pushing back on overly expansive claims. So it's an interesting issue, and I know that it's a very topical here in Mexico.
So what do you think, Alejandro? Do you think have a new scheme to cooperate more and maybe the attorney-client privilege provision will help?
Yes. I also believe it was important that it was the first chapter to be closed, which means that we are working in a convergent way of applying the competition policy in the three countries. So that's an important message. In terms of the client privilege issue, as Matthew says, there has to be, we have to strike the right balance. So what we're working on, and this will be put out in public consultation maybe the 20th of this month, at the end of this month at latest, is how in COFECE we're going to handle the information that is called upon. So we're not going to, so there's an issue in Mexico that the attorney-client privilege is not well regulated in the laws. So it's a new issue for the competition agenda, but also in general. So we're not going into regulating or the issue. What we're going to do is we're going to put forward a procedural mechanism. So whenever there's a downgrade or whenever we ask for certain information and the attorney claims the privilege, how will that be processed within the commission? So we would love the three agencies here to let us know their opinions on this procedure. We've had conversations with the three of you before, so we think that procedure has best practices, and we will also be interestingly listening to what practitioners have to say. And we know that that consultation will raise issues, but it's part of moving forward.
Yeah, I think so. It's great that you're tackling that issue in Mexico as well. I would like to ask a more general question regarding updates with your work at the agencies. What are you up to in the different jurisdictions? What are your priorities? What are your main cases or your main interests at the moment? What's going on? Can we start with you, Joe?
Sure. So one of the things that I realized as soon as I got to the FTC back in May was that the Commission was engaged in a historic level of litigation. We had 14 cases that were then active in litigation, 4 merger cases and 10 non-merger cases. I couldn't remember in my lifetime having 4 merger cases being litigated at once. Mm-hmm. That's a big strain on our resources. And so this actually started, this emphasis on litigation started the last time that I was at the FTC. We went out of our way back then, this is 15 years ago, to reinvigorate litigation as a tool for enforcement at the FTC, and that's continued and expanded dramatically in the 15 years that I was away from the agency. So that still will be a very big emphasis for us. Another big emphasis for us, of course, is healthcare, and because healthcare is such a huge part of our economy. It affects, everyone in very significant ways, and of course, as you all know, probably people are very concerned about cost and pricing in our healthcare system. And so we want to focus and make sure that we are doing whatever we can to stop the anti-competitive aspects of things that are going on in the healthcare arena. And we're very active in that. We've got litigation involving what we call reverse payments or pay-for-delay situations. We've got big litigation involving sham petitioning of the FDA, a big litigation going on with respect to that. And then we've got a bunch of hospital merger cases that we're emphasizing. So that, at a high level, that's what we're doing on the enforcement side. And then on the policy side, we have instituted a large series of public hearings that are designed to get the antitrust community in the United States talking to each other. We've had a very strong bipartisan consensus on how to do antitrust enforcement and policy over the last 25 years. But over the last several years, that bipartisan consensus has been weakened somewhat. And so we want to do what we can with these hearings to kind of make sure everyone gets a chance to talk to the FTC, the DOJ, and talk to each other and try to reinforce the consensus going forward.
Interesting. Very good. Megan, what are you up to in the DOJ?
Nothing.
Yeah, right.
We've been doing...
No good.
Yeah, that's exactly, depending on who you speak to. But it's been a great economist at the University of Chicago who's a dear friend recently, as we were trying to woo him to come over to the Justice Department, said one thing. He said, what's exciting about what's going on the past year, the Justice Department, is that you guys have been really active without being activists. And I took that as a compliment, and we have been. So there's been several matters that obviously the big merger litigation that we're involved with is the AT&T Time Warner, where we challenged a certain portion of a major transaction while recognizing pro-competitive efficiencies of other portions of it, and it's up on appeal now. It will be argued December 6th, hopefully we have an agreement with the parties not to combine certain provisions of the transaction and hold them separate through the end of February with the hope that we'll have a decision. So maybe we'll get some clarity not only on our enforcement powers, but what the courts think in this area. So that is to be seen, but that took a lot of resources. It took a lot of effort, resources before I got to the division but also in litigating that. And that was an interesting one where, in the civil context, attorney-client privilege became a big issue, partly because of the way that litigation was structured. We had several months basically with the judge to get through $108 billion merger. But there were, I believe, over 600,000 documents that were claimed to be under attorney-client privilege. That tells you the need to have limits on attorney-client privilege so it's not abused. And I'm not making no comment on whether or not it was abused in that particular transaction and litigation, but it's really important to understand, not only is it really important to have frank discussions, but it's really important to also know the contours of that and the limitations. And that continues to be evolving in our law. So on the merger side, we have had a number of other ones, including Bayer Monsanto, Disney, Fox, and others that we've worked with COFECE and continue to do so in a very cooperative way, Dow, DuPont, and others. We've also focused on the issue, and we had some workshops about a year ago on this, on regulation and the deregulatory aspects of providing competition. Are there government regulations that actually harm consumers? And what could we do, whether it's through competition advocacy or lawsuits that we have been doing jointly with our friends at the Federal Trade Commission, where we have filed some amicus briefs and statements of interest in courts of appeals and district courts in areas where you have either industries that will pop up at the local level and have some favorable regulation that benefits them to entrench and protect new competition from coming in from new technologies. So that's been an area that we're continued to focus on, added some additional resources in that. Related to that, we've kind of gotten back to bringing competition enforcement back to a law enforcement function for us at the DOJ, rather than a regulatory function, which meant that we updated our consent decrees and the way we approach in merger cases our consents to make them more enforceable by getting agreements on the standards of when you make a commitment to resolve an anti-competitive provision of a merger, you shouldn't be able to walk away from those commitments because of ambiguities or lack of enforcement powers. So we wanted to make that as easy as possible, in a fair way, so that we can enforce those consent decrees going forward. We have also engaged in a lot of about 1,300 consent decrees that remain on the books with the DOJ that regulate all sorts of important industries, and some of which regulate absolutely nothing, but have been on the books, and some of them have become anti-competitive in their nature. And so we're carefully reviewing all of those and have begun the process of going through our court system and terminating those and letting the free markets decide. On the international front, that there's been, I don't think, a secret that, along with our colleagues here on this panel and other agencies around, we think it's time to have a broader agreement on procedures, and we have an open process that I'm glad we have at least a dozen partners who believe similarly that it might be time for us to commit to each other to provide some of these basic minimum standards that we can agree to, and we hope that in the coming months we have that in a mechanism by which all the 140 antitrust agencies around the world could commit to them and adhere to those principles. Doesn't create private rights of action or anything, but creates an ability to have dialogue and capacity building on some of these issues on process. I think that's an important part at the juncture we're in antitrust enforcement globally.
And you continue working with the ICN and the OECD on this procedural fairness work that you've been encouraged for a long time, right?
Well, absolutely, and I think the ICN, the recommended practices, and the OECD, both of those organizations have played a very valuable and important role in advancing those. And I think both of those envision bilateral or multilateral agreements amongst people, amongst agencies, to be able to advance that to the next level. And we hope, and those discussions are very open, very frank, and very good, and I think very positive so far.
Very interesting, this more fairness in procedures. Alejandra, can you tell us what the COFECE has been doing. Of course, we know COFECE has been very, very active, but maybe you can give us an
Well,
overview.
specifically yesterday, where we announced a non-poach agreement investigation, first one in its type in Mexico. It's related to the recruitment of professional soccer players in Mexico. This morning I was skimming the, our media analysis. It's really impressive how soccer makes news. Never in our life, under any circumstance, whatever decision we've taken, amount of sanction, we've been in the press more than this issue. Also yesterday, I was revising my Facebook, and a colleague of mine who's sitting there wrote a note in her Facebook saying, COFECE is everywhere. And I thought she's right. So we have high impact investigations in the financial sector, in the transport sector, in the energy sector, public procurement, eggs, airlines, passenger transport. So I believe we are everywhere. And now what we have to focus on going forward is on delivering those investigations. So I believe that what we're going to see the next few years is a focus on handling those investigations rather than opening up our agenda. And one of the things I'm more delighted of in this 5 years is not just that the agenda of investigations have broadened, but the impact of those investigations. When we first arrived to the Commission, what we had were investigations regarding the aluminum piece of the little part of the machinery in a car motor. And now we're analyzing liquid gas petroleum or passenger transportation or financial services. So we've been building up on past experience, not just on handling on investigations, but on doing things that are, I believe, are important for the Mexican economy. In terms of mergers, we've put forward an electronic mechanism, which I think has been very successful.
Yeah.
And basically I say that because in the last, 3 or 4 months, not a single practitioner has called upon my office telling us that we're taking too long. So I think the system is working. And we just received a new merger analysis regarding Walmart, which is the biggest tienda de autoservicio grocery store in Mexico, and Corner Shop, which is an electronic platform. So it's the first time we're going to analyze a merger in the digital economy. So that's interesting. I don't want to put forward an opinion. It's just interesting that we're starting to have analysis regarding the digital economy. And in terms of policy or advocacy, we'll have a new government taking office on the 1st of December. So we've been concentrated these past few months on building the links with these new governmental officials and putting forward our ideas in terms of how them with their policy powers and their sectoral regulators can build on creating competition in the market in the sectors that they regulate.
Two follow-up questions there. I do believe the electronic system for merger procedures is very good, and a lot of people are feeling that times are being reduced in the merger review process. Do you think it will align more with the US and Canadian systems and allow for more cooperation with your counterparts?
The next phase would, the next step in our merger procedure would be to have a first phase, second phase type of analysis. The issue there is that to do that, we need a modification in the Competition Act. So we're trying to be very diligent with those cases that, in our view, don't pose any risk to competition. But really the next step would imply a modification in the law, and that's not in our hands. So with the actual law, we'll be working as diligently as we can. So yeah, I think that's what we can do. But I think that we've always been able to cooperate. So I've never heard that there's an issue between cooperation within our agencies. I think it's not just that there isn't a problem, I think we're very good at cooperating.
Very good. And regarding the financial sector, you opened an investigation in card payment systems recently that has to do with barriers to competition and essential inputs. I think that's a very, very interesting case, and it builds on these other cases that you have on the financial markets and the studies you've made. What do you anticipate in your interest in the market, and especially with the fintech coming as the next frontier in financial sectors?
Well, we first started digging in our nose in the financial sector in 2014. Mm-hmm. And it all began when Congress mandated us to elaborate a market study on the financial sector. So we put that study forward in that moment, and maybe it was thought that that document wouldn't have more consequences. But it has had, in the sense that as a competition agency, we learned about how the financial sector works. And we've always been very transparent in terms that the financial sector is a strategic sector for COFECE. Mm-hmm. So we've been building upon that knowledge, and what we've seen is 3 investigations. And one had to do with retirement funds, which was sanctioned, which is one of the most important cases we've handled in these 5 years. The other one, which is being analyzed right now, has to do with credit information. And then this new one, which is a little bit different because the credit information investigation has to do with abuse of dominance. And this has to do with barriers to competition. Mm-hmm. So it's building on our previous knowledge. And in terms of fintechs, we've been very outspoken in terms that the new regulation put forward in Mexico should create more competition. When you analyze why the Mexican banking system is so concentrated, a lot has to do with, in my view, sectoral regulation being very lax with them, or the lack of the application of the regulation with the big banks. Interesting. And I think the fintech sectors think they are allies, because more often than not, they knock on the doors of the competition agency asking us to advocate for them, because they usually find that the traditional sectoral regulators do protect the big banks.
Very interesting. What about Canada? How's the Competition Bureau doing these days?
So clearly we're in a time of transition. Commissioner Peckman retired at the end of May, and I was appointed on an interim basis for up to a year. Government's working its way through the appointments. So we're not doing anything, just like Macon. We're just waiting. No, that's actually not true at all. The reverse is true. We're extremely busy pushing forward on priorities that were established last year under Commissioner Peckman.
Probably the most notable one is a real emphasis at the Competition Bureau on the digital economy. Wherever we have an opportunity to make an enforcement decision, to exercise our enforcement discretion, or to put forward advocacy, we're putting emphasis on the digital economy and how we can improve that in Canada, how we can enforce in that area. We are in the middle of creating the role of a chief digital enforcement officer, which we're hoping to find the right person to bring into the agency who can be strategic, who can see the landscape, not just in Canada, but internationally, because obviously this is a world without borders when it comes to the digital economy, and how we can try and stay ahead of the curve in terms of disruptive technologies, whether they're impacting consumer protection or whether they are in the antitrust field. So that is a huge emphasis. Our cases, some of our enforcement cases reflect our emphasis on the digital economy. Certainly on the consumer side, we're going after quite vigorously, going after things like drip pricing, astroturfing, and price representations online that are false or misleading. We recently had a case come to an end involving a real estate board in Canada that was all about innovation in terms of digital real estate services. So that is kind of the Bureau's #1 priority. We're doing that in advocacy as well. We had a fintech study in Canada where we advocated at the end of the study to provincial and federal regulators to regulate as lightly as possible in the fintech area to encourage innovation and competition, just like Alejandro was just discussing. We're doing a broadband market study now, and we've done advocacy in terms of other online sales practices. In terms of the more meat and potatoes issues in Canada, fortunately, we were just able to increase our merger filing fee. We're actually running our merger review process at a deficit up until earlier this year. We've been able to get the fees increased, which we think will allow us to move our files more quickly, which is obviously something the business community is always clamoring for, and we want to do. It's just always a question of resources. We're creating a mergers remedies unit, something that's being done around the world, sort of a strike force on how we structure our consent agreements, how we structure them so that they can be enforced properly, as Macon was discussing. And I guess finally, to round off the traditional antitrust in terms of our criminal matters, our price fixing and bid rigging, we have a huge emphasis on domestic cases right now. There's, I think it's been talked about around the world, there's been a bit of a slowdown in international cartels coming in via immunity and leniency. But that, in a way, has been fortunate because we have a lot of domestic cases, particularly bid rigging. And we have one massive domestic price fixing case involving allegations of price fixing the price of bread throughout the country for many, 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 many years, which is obviously, if true, if more than just an allegation, very serious conduct that impacts the Canadians in their pocketbooks. But the benefit of that case has been that it's really drawn Canadians' attention to the importance of vigorous enforcement of cartel laws. So that's kind of a high-level overview of what we're up to.
Very good. And your review of the leniency policy, was that a reaction of less interest in the program, less participants in the program, or why are you reviewing your leniency policy? I understand there's an issue in the world that we are seeing less interest in coming forward for leniency, but I don't know specifically about the Canadian case.
So the genesis for us to review our immunity and leniency policies we started back 2015, 2016. It took a long time. We just published revised versions in September. was a couple of court cases that didn't go perhaps as one would like, if I can describe it that way, where some witnesses minimized, some cooperating witnesses may have minimized their testimony contrary to what we'd heard before, and a push from our public prosecutors to take a look at the programs. So for those of you who aren't familiar with the Canadian system, we have a bifurcated prosecutorial model where the Competition Bureau investigates, and then we literally hand off the file to our federal prosecutors who, A, make a decision whether or not to prosecute, and B, conduct the prosecution. So in that regard, our immunity and leniency programs are jointly administered by the Bureau and the prosecutors, so we have to all be on board. There has to be certainty and predictability that both sides are going to follow the programs. So jointly, we said, let's take a look at them, and put out an initial draft that had some, I think it's fair to say, very controversial aspects to it. And we benefited tremendously from input around the world, including from the U.S. Department of Justice, the American Bar Association, the International Cartel Task Force. And we came back to a version that isn't terribly dissimilar to what we had, but it tweaks it a bit to address some of the issues. For example, in Canada, the reality is now that we want cooperating parties to provide us with records and testimony earlier. So we have a provisional grant of immunity to allow the flow of information. We expect parties early, not too early, hopefully, but early in the process to give, certainly individuals, to give sworn videotape statements so that should they decide to change their tune at trial, we have something that we can play for the court and cross-examine them on. Hopefully the prosecutors will. And I think for me, the most important change was to change our incentive program in terms of leniency. So we have immunity and then leniency. And the way it was under the old model didn't align with our friends in the United States, certainly, where the discount you were going to get for cooperating was based on the time you made a phone call to me in my old job as head of cartels. So if you were the first leniency party, you were sort of going to get 50%. Didn't matter if you were slow in your cooperation, if you were dragging your feet on providing evidence, and that always bugged me. So we've changed it now so that the value of your cooperation is going to come into play more, and that lines up more with the United States Department of Justice. So that second in, third in can actually get bigger discounts if they're moving the ball, if they're doing what they're supposed to cooperate. Because it's not just a discount program, it's a program that's meant to build cases to prosecute those who choose not to do the right thing. So that was a very long answer to a short question, but that's why we did it.
Very interesting. In the U.S., there's also been discussion of making some tweaks to the leniency program, right? I've heard about also the issue of changing the law on the treble damages that you have and the detrebling that is possible if you cooperate under the leniency program. Is there something that you can tell us about that?
Sure. So we're always looking at our whole cartel enforcement program, take a look and continue to improve that. So the law I think you're referring to is what we refer to as the ACPERA that was enacted in 2004, which said that if you are a successful amnesty applicant and come forward and cooperate with the victims, you could have detrebling of your civil damages to continue to add to the incentive for you to come forward and cooperate. And if the value, we leave it up to a federal judge to determine that as far as the level of cooperation and whether or not you're worthy of detrebling of civil damages. So that law has been reauthorized and continues to. We're constantly looking to see are there issues with it. Sometimes it actually brings in a lot of folks who don't have a a cartel to try to seek amnesty to get de-trebling of their civil liabilities in something else. So it actually isn't evidence, but they like to come in and force that type. So it brings in a lot of, especially in the early days, it was bringing in a lot of new applicants for things that weren't actually criminal. And so we have been continuing to look at that. So we're looking at a couple of areas. One is, and we had one workshop and we continue to study this, we haven't made a determination yet, is to see if you have compliance programs, corporate compliance programs that are good and effective, should we provide some credit down the road to encourage more self-awareness and education within the corporation. It is one where through our sentencing guidelines are addressed, but we want to study that. It's been something that we've talked about a little bit more publicly recently, and we're studying, so we might do that as part of our cartel enforcement program. Second, we are, we've had this authority, which we hadn't used in cartel cases, where the government, where the U.S. taxpayer is a victim. So you could, price fix on products that are sold to the U.S. government. And we'll have some announcements over the next few weeks about that. But we can seek treble damages on the civil side, in addition to the criminal fines and penalties. And we're going to probably be much more active in that area, where we have been the U.S. taxpayers are the victim, or the victims. We will recover on behalf of the U.S. Treasury. And with that, we are going to honor the same ACPERA. So we're going to use our discretion and only seek single damages if you have been a cooperator and amnesty applicant. So we're not going to seek treble. Again, that should help create more of an incentive to come forward to the extent there's been exposure on the U.S. government side. We are studying, and we have talked, I have a very personal view that I don't think our criminal penalties. Last time I was at the Justice Department when we enacted ACPERA, we increased the penalties from 1 million to 10 million for individual and corporate from 10 million, which was our statutory max, to 100 million now. You could imagine, especially in some of these larger international cartels, where you look at the damage that is done, some of which have been in the billions. Businesses begin making a business decision. Hey, all we're liable for is $10 million. Of course, they might fear about wearing pinstripe suits in our jails systems. But aside from that, you start making a cost-benefit analysis. And if the fines are only 10 million and I could seek $100 million in a year, outside of some district court judges who have recently reviewed some of our merger cases, that would make good business sense. And you would do that. And so we want to take a look to see if the 100 million makes any more sense for us. And maybe Congress should examine raising those to a certain limit. So we have been looking at all aspects, and I think all of us probably are constantly looking at all aspects of our enforcement regimes to see if we need to continue to fine-tune that on the policy side. So those are the few areas in our cartel enforcement that we're looking at.
Very interesting. Thank you, Mikel. You both mentioned the issue of when you have to go to the judiciary, it's another new game. It's a new discussion you have with the judiciary, and you've mentioned some interesting cases. Joe, you mentioned the issue of healthcare and the big pharma. How's it a challenge in the U.S. right now? You continue with this sham litigation that is very important. What else are you bringing before the judiciary, and what kind of reactions are you getting in this political scenario now with the judiciary?
So one of the big things we just got was a case that ruled for us that was on the sham litigation. So the Supreme Court issued an opinion in the 90s, I think it was 1993, that for the first time articulated a way to bring a sham litigation case, but no such case had ever successfully been brought until just now, where we have brought a case to do just that. And so we're very, very excited about that. We've got a few other cases involving these sham petitioning aspects. We've got, we're looking for cases involving product hopping. And we're also looking very carefully at mergers. Those are really the areas that we're looking at. And the other thing that we're doing is that we're working closely with the FDA and the Health and Human Services Department to focus on ways that even outside of antitrust enforcement, that we can do things to improve competition, perhaps from a regulatory standpoint.
Very good. Been involved in interesting cases against real estate agents and in the real estate industry. That's one of your priorities, right?
Yes, well, it's just come to an end in August of this year. It started in 2011. I'm ashamed to say that it was before the courts for 7 years in Canada. So by way of background, the case was against the Toronto Real Estate Board, which is Canada's largest real estate board, so a trade association of realtors in the Greater Toronto area. And they'd put in place a practice where they prohibited their members from sharing historical sales data via sort of online brokerages. Clearly, in our view, conduct that was directed at maintaining the market dominance of brick and mortar realtors and not allowing these innovative online realtor services. And they also prohibited sort of new analytical tools to look at historical sales data. In any event, the sort of battle began in 2011. We went to our competition tribunal, had a bad result, went to our federal court of appeal, got that overturned, went back to our tribunal, won, went up to the federal court of appeal, and finally the Supreme Court of Canada said, okay, enough. We agree with the Competition Bureau's position that what this real estate board has effectively been doing has been to try and protect the sort of bricks and mortar. They advanced privacy arguments about sharing this stuff online. The courts said, no, that's a complete pretext. It's really an afterthought to try and cover up your anti-competitive conduct. That was an abuse of their dominant position, controlling sort of the real estate services brokerage market in the Greater Toronto area. So it was a case that only related to one jurisdiction, but the importance of it for the Bureau and for broader competition issues in Canada was that it clearly talked about dynamic competition being the most important type of competition. The courts said that explicitly. The case received tremendous attention in the public, not just in the city of Toronto, obviously Canada's biggest city, but across the country. And it sent a strong message to other trade associations, other real estate trade associations, that this kind of conduct won't be tolerated, that the Bureau will chase it down, even if it takes 7 long years and a lot of financial resources and human resources to get there. The other real estate boards in the country are coming online now. They're following what the courts have said. And we will trot out some of the aspects of the ruling, particularly with respect to trade associations' ability to be dominant in a market in other areas. So we're very happy with the result, and it's another example of bringing competition to the forefront of Canadians' minds as being really important in their day-to-day lives.
Very interesting, and that's a good lead to the other topic that COFECE put on the agenda, and I think it's one of the most interesting discussions we can have in the antitrust world, that is big bad. Because traditionally, as we all know, being big is not bad. It's the abuse of market power that is bad for the economy and for consumers. So with this new discussion with hipster antitrust and with people telling us that we should be looking for other explanations or other objectives for the intervention of antitrust authorities, And with, especially with technological changes and the digital economy, there's a new discussion on this topic. I would like to ask all of you about this issue. How are you seeing it in your respective jurisdictions, and if we should be having a new discussion and a new model with these topics? Maybe if I can start with you, Joe.
Sure. So this is really quite interesting. I think it provides an example of how sometimes history just keeps repeating itself. So, you know, one of the hallmarks of a really competitive economy is disruption. Mm-hmm. So new competitors come in, they disrupt the incumbents. The incumbents often complain. Their business is being displaced. Oftentimes they run to the government for protection. This is like a common theme throughout history, certainly economic history in the United States. So if you go back, like you can think of it like going back to the era of the horse and buggy. Like, you know, Ford created the assembly line at the Ford Motor Company, and all of a sudden, people who were specializing in buggies and providing services for horses that were drawing the buggies, they were out of work. And I'm sure they didn't like it back then. So then another example happens in the retail sector. You have this company in the United States called A&P. I can't remember if they were in Mexico or Canada or not, but they were huge in the United States. And what they did is they engaged in vertical integration in the food retailing business. And they did that by establishing their own distribution network. They did that by producing, in many cases, their own food products. They became much more efficient, cost-effective. They produced better products at lower prices and had nicer stores. But the people who were competing with them, who were there before A&P showed up, they weren't very happy about it. They were disrupted. So A&P looked like a juggernaut. But what happened is other people came in to compete with A&P, and A&P is basically almost non-existent, or maybe they are non-existent today. And you've got a very competitive retail grocery business in the United States. And then another disruptor came along to disrupt that situation, which is Walmart. So it just happens continually over time. And in fact, what happened with A&P is people at the time that A&P was really coming in and making all this progress, they were attacked as being bloodsuckers and big. They're called all kinds of horrible names. Big is bad was used. So that's just another example. And you can overreact to this type of thing. And I think history shows that. So we need to be careful about that.
Very good. Matt, what do you think in Canada?
So the big is bad sort of debate hasn't caught on as much in Canada as perhaps in the United States and certainly elsewhere in the world. There is normally a saying, when America sneezes, Canada catches a cold. But it's not applicable in the sort of big is bad populism, antitrust discussions that have been picking up some traction. We simply, in Canada, don't have a strong or recurrent populist tradition. For some reason, it's not part of Canadian DNA, at least not yet. So Bill Stanbury, I'm just going to give a quote here, a Canadian antitrust scholar wrote that Canadians, unlike Americans, have never inherently distrusted power, whether economic, political, or social. I'm not sure that still totally applies, but we haven't, as I say, we haven't caught the big is bad bug as much as it has elsewhere in the world. And under our law in Canada, at least the Competition Act, it's very clear that you need to be big and bad. You have to do both. Big in and of itself, unless it's through anti-competitive mergers, is not a problem in Canada. In fact, we're at the Bureau, we're of the view that if you treat big as bad, you take away the incentive to get big. And that's what drives an economy, and that's what drives innovation. So to go down that road is not somewhere where we, at least at the Bureau, want to go. We want to remain focused on economic harm. Where's the blood, as John Peckman used to say. Keep our focus in that area. If governments choose to introduce public interest considerations into this area of decision making, then preferably it would be outside the context of the antitrust enforcer.
Yeah. What about you, Megan? What do you think? Especially in the digital economy, you gave a lecture yesterday. It was amazing. I really liked it on how things are changing with the digital economy and what's coming in terms of these challenges that we see in being big is bad. No?
Well, thanks. Thank you for that. I have a different view. Big is bad. Our job is to break anybody over a 20% market share.
They're recording.
That's what antitrust is. See, that is
It's very nervous.
well, this is exactly the reaction that thought should get. That's exactly it. And that's, this debate, I encourage it because I think we should always have a good, honest debate about roles of competition law. But that just shows you how ridiculous some of this whole debate broadly is. Some of it is legitimate. You have network effects of digital economies, and you want to be sure that when big gets big, it doesn't misbehave like we saw some of the evidence in the Microsoft case 20 years ago. But the antitrust laws, we need to review them, but they have been unfairly, I think, criticized by some of the folks who enjoy doing that, as somehow it's a myopic view of a downstream price effect of transactions or conduct, which I think the consumer welfare standard would be, I think the broad consensus is that it doesn't just look at price. You look at price, you look at output, you look at innovation, you look at quality, you look at choice, and we do that, and we all, in our reviews, do that. And of course, big is not bad. Our Supreme Court repeatedly has told us, that is exactly the motivation for the type of dynamic competition it is. I've probably said it more times than any of you want to hear, and a lot of us, but I think this debate is good. I commend, Joe and the FTC and the workshops they're having to allow that discussion, and I commend, some of the academics who write about that because it creates, one, greater awareness of what antitrust law is, but even more importantly, what antitrust law is not and should not be. And so I'm glad we had that reaction to what I said in the very beginning, because that is exactly the type of reaction we should get when somebody says that big is bad.
Very good. Alejandra, what do you think? In Mexico, I feel you're receiving more pressure in other markets, maybe not the digital economy, but maybe other markets.
Well, yeah, as Matthew said, that the discussion has not caught up in Canada yet. I would say that this discussion has been around Mexico the whole time I've been in this business. And at the beginning, it was very hard to explain to the media why we wouldn't directly go to big companies. So there's always an example I like to put forward, and there's this specific market, the specific company that produces a good that is important for the Mexican consumers. And if you analyze its HAI, it has around 9,700. So that's what the company has for that specific product. So why don't you do anything about it? No, that's the question. Why don't you do anything about it? And then I'd say, well, we could go in if it's big, if it abused of its power. But since it's been in the market for so long, and previously it eliminated its competitors, nobody wants to go into the market these days. So it doesn't abuse of its power because nobody even wants to challenge its power. So we can't use that tool. And then the other tool is that maybe it's fixing prices with its competitors, but since it has an HHI of 900, 7,000, it doesn't have competitors. So you can't go through that. And then in Mexico, we don't sanction excessive pricing. So unless there's a case of abuse of dominance, there's nothing we can do about that big company. Okay. So it took us time to explain that to the press. I don't know if we've been able to put that forward, but I as all my colleagues are saying, the Mexican competition law does not sanction big, sanctions bad, and we need to comply with the law. So that's the way we have to act. On another aspect, they were saying that history keeps repeating itself. And I was reading the other day that if you want to understand what will happen in economics in the future, what you have to do is study the past. So bringing that to Mexico, if we analyze why we have these big companies, because we do have highly concentrated markets, and we have to be very clear in that, we cannot sanction them, but we have them. In many of those cases, it's because the regulation was not put in place, the regulation was not applied, or the regulation was applied to favor certain incumbents. So we need to learn from our history. So in the future, if we don't want big companies, what we need to do is regulate properly. And then that takes me to the digital economy, where as governments, you need to decide when to intervene and how to intervene. And those are the really difficult questions. I think there's no consensus on when to intervene and how to intervene. And sometimes when you read these hipsters' analysis, things get mixed, because there's an issue with market concentration, but then there's an issue that this market concentration gives you power to interfere in political issues, and then there's also a privacy issue discussion. So it's not all a case of a competition matter, and of course I don't have any answers, but I do have a lot of questions. And I find interesting, for example, that the European Commission has been regulating on how to handle data issues. So, in a nutshell, big is not bad. Our law does not permit us to sanction. We have big companies in Mexico, and we need to acknowledge that. And in order, in the future, to diminish the possibility of having bigger companies, a lot of regulation needs to be put in place in certain markets.
It must be difficult, Joe, for you or Matt, to handle these different interests or public policies together, like privacy in contrast to competition, or consumer protection in contrast to competition. How do you handle this in a very important institution in the US economy like the FTC?
Well, for us, we view competition policy and consumer protection policy as synergistic. So in many cases, the point of consumer protection is to allow the consumer to get information that allows the consumer to make a good choice, which furthers competition, right? Because if the consumer is uninformed, then it's more difficult for competition to be effective. So we view those as very synergistic. And one example where you have to be careful about what you're doing on the consumer protection side because of its potential impact on the competition side is just what Hannah mentioned, alluded to, which is privacy regulations. You want to be very careful about whether you regulate privacy in a way that dramatically impacts competition. One of the concerns that people have expressed so far with respect to the European Union's new GDPR regulation is the concern that it will entrench particularly large digital platforms, because the law requires consumer consent before the information can be used, the data can be used, and those companies are in the best position probably to get access to that data and use it, whereas like for example, small companies or new entrants probably will have a much more difficult time getting access to the data under those circumstances. So there's a concern that by furthering privacy in that particular way, you may actually hinder competition and harm consumers. So that's something, I'm not saying that that's going to happen or has happened. What I am saying is that's something that we're very interested to look at and see how it progresses.
Very interesting. Matt, would you like?
So just briefly, I completely agree in terms of the relationship between consumer protection, or at least the mandate we have in consumer protection, which comes down to false or misleading representations, which is giving consumers true information about the transaction, the good, the service, and how that ties to competition. Because if you're lying to people to get their business, to steal their business from your competitors, they're so inextricably linked. I think there are interesting connections with privacy, and in Canada, we have a situation where we have a privacy commissioner who, unfortunately, we have a very limited ability to work with in terms of enforcement. And there's more and more conversation in Canada that there needs to be, the walls need to be broken down between the competition enforcer and the privacy enforcer. And I think that as those voices get louder, we'll be able to do that. And it'll be very important because the connections on data and personal data and use of personal data and competition are clear, as Joe was saying. And in consumer protection, personal data, the notion, one of the things we're looking at very closely is, the notion of a free app. But actually, what you're giving up to get that free app is your personal data. And that, a lot of times, is not upfront as part of the transaction, as a sort of misleading to consumers, because your data has great value in 2018, your personal data. So it's obviously very complicated, and we're trying to figure it out as it develops.
Alejandro, you want to mention
Yes,
something?
I just wanted to say that in Mexico we will have, as the digital economy comes upon us, an institutional complication, I would say.
Fight, maybe?
Because we have a sectoral regulator who also has jurisdiction and competition in broadcasting and telecommunications. And then we have an agency responsible for regulating privacy issues. And then we have a consumer protection agency, and then there's us. So that's something we need to start thinking as the economy evolves. I believe, I like very much the FTC's institutional arrangement because you can investigate in the consumer or privacy or competition bucket, and then whatever comes out, you can start investigating because it's a privacy issue, but then at the end of the day, it can turn out to be a competition issue. So I think that flexibility for this new world is something that the FTC has on its favor.
Yeah, we have some experience dealing with these interagency conflicts. So we have an FCC, a Federal Communications Commission, and they, a couple of years ago, passed a regulation that divested the FTC of our jurisdiction over the internet service providers. And we didn't like that very much.
Interesting.
But we got it back, at least temporarily. So we're much happier.
And that takes us to a broader discussion on regulation versus competition, right? And you've been very active, all of you, in terms of advocating for pro-competitive regulation, or sometimes, as you mentioned, not regulating at all is the solution for some of the market problems. So what have you been up to in this regard? How are you treating this relation with sectoral regulators in general? Alejandra, you've been very active in the advocacy front with Tabasco, the rules for procurement in this region of Mexico, and other similar cases. What do you think about this issue of regulation that impedes competition?
Well, I think everybody in this room understands this, but you have ex-ante regulators and ex-post regulators, no? And we are ex-post regulators. So we work with the rules of the game that ex-ante regulators put forward, and within that framework, we sanction those who do not comply with our respective competition acts. But if the rules of the game are not well put, then competition will not flourish as it could. So that's why our relationship with sectoral regulators should be very, very important. And as I've said, and I think I've been saying this too much, when you try to understand why Mexico has such concentrated markets, a lot of the explanation has to do with a sectoral regulator that did not act accordingly, in my personal point of view. So it is important for us in the Competition Commission to work closely with sectoral regulators because at the end of the day, we can only do so much. So many of the things we do also need the help of the sectoral regulators. And there's a perfect example of this. We've sanctioned twice taxi airports. And we've done that in the past year and a half. In one case, we sanctioned the airport because it discriminated between taxi agrupations, concessionaries. So we treated some concessionaries in one way and treated other concessionaries in another way. And then we also sanctioned the concessionaries themselves because they fix prices. And at the end of the day, and I think we have to say it, nothing has changed in the Mexican City Airport. And why haven't things changed? Because the model is broken. So as we put forward both sanctions, we also made public an opinion where we asked Congress and the transport regulator to open that market to competition. And that's really what will change the face of that market. So examples like those, we have many, but that's the relationship between antitrust and regulation that needs to be understood in Mexico, at least.
Matt, in Canada, how do you liaise with the regulators? You have these kind of fights?
So we've been doing a lot more of it in the last 5 years, advocacy and outreach to regulators. We're somewhat limited in what we can do in terms of making submissions and interventions to regulators just by our act itself. And we also use market studies to sort of advance notions to regulators in terms of how things might be better done. But in the last couple of years, we've had some, we believe, great examples. In 2015, with respect to Uber and ride sharing, the Bureau put out a white paper that laid out the advantages to competition of lifting some of the regulations that prevented ride sharing like Uber and Lyft in various jurisdictions in Canada. We were fortunate that many municipal governments picked that up and pointed to it as a reason to deregulate the taxi industry in their particular jurisdiction. Obviously, some municipalities didn't necessarily listen to our advice, and certainly it was dangerous for Competition Bureau people to take taxis after we put out that white paper. And then, as I mentioned earlier, in 2017, we did a large market study on fintech, where we actually worked with the regulators and put forward recommendations on the going forward, as Alejandra said, what they're going to do in terms of regulation, not what we'll do after the fact. And those are being picked up now by different regulators within the economy. And most recently, through an advocacy piece, through a sort of document that we publish, we made arguments to regulators in the eyewear industry where there was There's ongoing efforts to limit online sales of contact lenses in Canada, and we're clearly of the view that that would diminish competition, excellent innovative competition that was coming online across the country, so we put that out, and it once again got significant traction, and we're hoping that certain regulators will listen to that piece. Going forward, well, sorry, the one other I should address is our telecom regulator, who we regularly are invited to make submissions to. I think we've made 9 in the last 5 years on various different issues. Most recently, we made submissions on low-cost data-only plans for wireless, which is something that doesn't exist in Canada, but that we believe would enhance competition.
Yes, very. One of the things that was re-emphasized by my predecessor, Maureen Oldhausen, involves occupational licensure, and she formed this economic liberty task force to pursue that. This has been a focus of the Commission for 30 years or more, maybe 40 years, but it was reinvigorated under Maureen. And we're very active, we continue to be very active in that area. You know, it used to be the case that in the United States that not too many people needed to get a state license in order to practice their trade or their profession. But nowadays, the extent of state licensure that's required across professions is very large. And oftentimes, the licensing board is composed of the people who they are regulating. So it creates all kinds of conflicts, and if you're not careful, bad things can result. So we're very active in looking at these at the state level, also trying to propose solutions to issues involved. So one of the issues that we're focused on relates to our military people, particularly the spouses of our military servicemen and women, who get transferred very frequently across the country. And if they're in a profession like, say, nursing or something, every time they change states, they have to get relicensed. So we're trying to develop protocols to make that relicensing much easier and reduce barriers to competition. That's one example.
Megan, you are the prosecutor, but you also engage in advocacy.
We do, and unfortunately, unlike our friends in Canada, we're not limited to be the officious and our meddlers and our friends in the regulatory agencies. So we have an interesting relationship in that under a particular statute, the economic regulatory agencies like our energy regulator, FERC, or FCC, our telecom regulator, or Surface Transportation Board and all of them, when they issue rules that gets challenged in the courts, it's been delegated to us, which is something I didn't know until 15 years ago, the role to serve as their lawyers in the courts when the U.S. is the defendant of that. So we join in, and because of that, we engage in a pretty robust discussion about how a case or a rule is defended on economic regulatory grounds. For example, our recent net neutrality rules in the United States by the FCC, or media ownership rules that occurred about 10 years ago. Those are going on, as is some electricity line licensings that goes on. And so we get involved with that. We provide comments to them, and through our regulatory oversight body at the White House, which serves as kind of a clearinghouse for those regulations. So we provide comments, particularly if there's rules that would cause competitive harm, such as you might have a parochial interest by a particular senator or congressman. Congress passes a law to create a monopoly for shrimp in a particular region of the country, or milk. That might be interesting and good for the consumer or for the producers there, but it's not really good for the consumers, and we'll provide that comment to our Department of Agriculture and all that. I just have, I think there's issues of regulation. When it comes to health and safety, like the FDA and a few other agencies that do that, I think those are very legitimate. When it comes to economic regulation, as I mentioned yesterday, a lot of times they're because it takes a while for them to move it's usually a sign that the market has failed. And where you have, I think, strong and timely antitrust enforcement in those markets, hopefully it would prevent the need for that kind of economic interference about how many customers you should have, what market share in a particular industry. Those should be left to proper antitrust enforcement. And usually when I see economic regulation, it should not be celebrated, but rather it should be a sign that something has failed. Yeah. And hopefully we can prevent that with proper antitrust enforcement going forward.
We have taken too much of your time, but if you allow 2 or 3 questions from the public, we can open the mic for you to make questions if you have. Here is one. Les pediría la pregunta sea muy puntual para hacer un comentario.
Hi. Well, first of all, congratulations for the panel. It was a great exchange of ideas. The first question, the people from the DOEA mentioned the follow-up of remedies or commitments like one of the key parts in mergers and acquisitions. In Mexico, I think is one of the big challenges, how you can make this follow-up. The question is for these 2 authorities, Canada and US, if there's a kind of a best practice to make this follow-up. In some jurisdictions, you have, let's say, a trustee who's in charge essentially of making this follow-up, and you only report to the Competition Commission about the evolution of these commitments. In other cases, the question is more related with the authority itself taking charge the follow-up of these commitments. So the question is, if there is any evidence that one of these or any other tool is more efficient than other in order to make sure that these kind of remedies are implemented. My question is, it's nice to design and to discuss the remedies, but if these remedies are not implemented in the right way that competition authorities are thinking, essentially they are useless. So is there any best practice in North America about how to make sure that these remedies ex post can be implemented?
I think you touch on a very important issue. It's something we discussed a little bit earlier as far as where you have some remedies. So making sure that they're effective and they're actually adhered to going forward. When we have remedies in a consent decree in a transaction, you want to be sure, whether it's been a promise to sell a business, if it hasn't been dealt with up front, you want to be sure that it goes through. We have very close, we have a judicial oversight of some of these consent decrees under what's called the Tunney Act. That goes on, but the Justice Department continues to do that, which is one of the reasons we prefer structural remedies rather than behavioral wherever it's possible. So one, it's to do that. Sometimes we have used, and in where you have a much more entangled and a more difficult transition period for those divestitures, like in Bayer Monsanto, we've recently appointed former Attorney General Michael Mukasey, who was also the former Chief Judge in Manhattan in New York, to be the monitor and to ensure that the transfers and the sales are done in a proper fashion that could report back to us and regularly would, because we don't have those resources to do that. We prefer not to do that if it's possible, but that is one way in a transaction such as that where we have done that. I don't know if we have any kind of guideline of best practices. A lot of these depends on the experience over time of how you do that. Sometimes we just defer to the merging parties to have an internal compliance monitor that will ensure and report back to us. The most important thing of that is to have the follow-up, to have the resources to ensure that that consent decree, those promises are dealt with. Again, going back, a lot of times, the legal standards we have to meet and the resources is really important, so it dictates which approach we take.
¿Alguna otra pregunta? No? Well, thank you very much for taking the time to be here and this lively discussion. Thanks.
Thank you very much.
Thank you all.